This morning we are going to have a very special guest here. Jenny Johnson serves as the President and Chief Executive Officer of Franklin Templeton, a financial institution that manages assets worth $1.5 trillion. The company, which is 76 years old, was one of perhaps 12 companies that launched a spot Bitcoin exchange-traded fund ETF within that week after the SEC gave its approval. On this set, it is wonderful to have you here with us, Jenny. You are so kind to have me. Begin with the Bitcoin exchange-traded fund ETF. I would of course be interested in hearing your opinion on the markets. However, with regard to the Bitcoin exchange-traded fund ETF, we have witnessed significant inflows. It was a reasonable expectation in the beginning. What are your expectations for the future, and who do you believe will be the additional investors in this exchange-traded fund ETF? I am renowned for stating that Bitcoin is the greatest diversion from blockchain, which is one of the largest disruptors in the financial services industry. It is amusing because I am recognized for saying that. Considering that I am not a believer in Bitcoin, a lot of people took that to mean that. In spite of this, you should know that the introduction of an exchange-traded fund ETF demonstrates that there is a clear demand for Bitcoin. In my opinion, there are a great deal of reasons why that is the case. From the perspective of blockchain technology, I believe that the ability to pay is the first. The use of Bitcoin is going to be an essential part of it. Furthermore, the technology is going to make available a great deal of potential investment options that are really intriguing. In reality, we introduced a tokenized money market fund to the market. We are the first traditional asset management or mutual fund to really create a 40-act fund on a public blockchain, namely on the Stellar blockchain. This makes us the first organization of our kind. Therefore, Bitcoin is merely one of the many opportunities that we believe are available in this context. One of the things that made me a believer as a support around the world, talking to people who would tell you, I had somebody said I keep 50% of my savings in Bitcoin because I say the wrong thing in my country, I could have my assets confiscated. I remember talking to somebody in Israel who said my parents and their parents had all of their assets confiscated. They keep up a portion of it in big points. So there's a fear component to it that is considered almost an insurance or safety component. On the other hand, I believe that it is of utmost significance in terms of feeding what is the next meaningful opportunity in this blockchain environment. And by that, I mean the scenarios that you just described. That is the argument for keeping Bitcoin. The actual, you have the keys to the security as opposed to investing in an exchange-traded fund, right? Therefore, there is a use case for both of them. Certainly, but that does not eliminate the possibility of a price floor, does it? In order to maintain the price at its current level. That being said, if you have actually attempted to obtain and deal with the keys, you will find that it is extremely difficult. It's true. Right? I mean, I did that at one time, and then I was trying to find out how to actually get back in, and it's a difficult process. In light of this, the ability to open it up and have access to it through an exchange-traded fund ETF as well as through your brokerage account is a far more advantageous approach to gain access to it. The comprehensive investigation into securities that was conducted by the United States Securities and Exchange Commission. It is possible that the cases will be resolved with the resolution of the well-known Chevron agreement. The decision of the court puts an end to the stringent regulatory regulation. The Supreme Court of the United States reversed a rule that had been in place for a long time and had allowed federal authorities significant regulatory power. When regulatory agencies like the Securities and Exchange Commission make changes to regulations, they must first receive approval from Congress before such changes may be implemented. This decision established the principle that courts should trust the judgment experience of regulators, as stated in the case that took place in 1984 between Chevron and the National Resources Defense Council, in which the language of the statute is difficult to understand. During the time that they were waiting for approval from Congress, these regulatory institutions were well known for providing interpretations of the laws that they were responsible for upholding. The fact that they are ultimately regarded with such respect is the reason why regulators continue to take action in situations where time is critically important. After careful consideration, Chief Justice Don Robert came to the conclusion that the Chevron deference rule could not be imposed. He made reference to the principle that allows agencies to make modifications to their plans, even if Congress has not given its approval. On the other hand, the administration of Vice President Joe Biden is putting out a proposal to challenge the decision of the Supreme Court in order to maintain the Chevron defense standard. According to the government, the pursuit of Bitcoin businesses by the Securities and Exchange Commission (SEC) is the fundamental basis of administrative law. In the continuing crackdown that the Securities and Exchange Commission has been conducting, some of the exchanges that have been targeted include some of the most prominent names in the cryptocurrency business. The Securities and Exchange Commission enhanced its enforcement methods in order to justify the ban of Bitcoin trading on exchanges. In general, the Commission positioned the How test as the primary topic of discussion to be discussed. Has avoided conducting business with a number of cryptocurrency exchanges, including Kraken, Binance, and Coinbase. Considering that the criterion continues to define XRP as a SEC. According to reports, these exchanges engage in the trading of registered securities via the internet. The inability of Coinbase to comply with the Freedom of Information Act and Zikaki's request resulted in a legal conflict between Ripple and the securities regulation that lasted for 3 years between the two parties. As a result of this, the ruling issued by the Supreme Court established a standard for resolve any outstanding disputes pertaining to cryptocurrency. A petition has been submitted to the court by the Bitcoin Exchange requesting that the Federal Deposit Insurance Corporation be compelled to provide the necessary information it has sought. The Commission is currently working on submitting a complaint against the corporation in order to impose sanctions. As a result of this most recent development, which comes immediately after the United States Supreme Court made the decision that individuals accused of fraud should be allowed to face federal court procedures with a jury, the power of the Securities and Exchange Commission has been significantly reduced. The Chevron defense idea was virtually undercut as a result of the court's action, which resulted in the court's interpretation of federal regulations being reconfigured. A stark reversal from previous judgments, in which courts normally depend on the knowledge of government institutions to interpret ambiguous statutory phrasing, this judgment represents a significant departure from that previous practice. It is possible that the verdict will have an effect on laws that deal with consumer safety and the environment as well as other regulatory sectors, because it gives the courts the authority to interpret these standards rather than agency experts. The agency's interpretive power has been diminished as a result of the Chevron reversal and the discontinuation of Chevron's defense program. In the past, judicial deference has been of assistance to federal agencies like the Environmental Protection Agency and the Securities and Exchange Commission. This has enabled these agencies to apply expert judgment to difficult issues that fall under their jurisdiction. On the other hand, according to the most recent ruling issued by the court, federal courts will no longer be required to rely on agency interpretations when they encounter interpretable congressional law. The regulatory authorities occasionally require assistance in order to implement and enforce the regulations that are currently in place. This is due to the fact that agency interpretations lose some of their clarity. With the adoption of this reform, a new century of legal interpretations has begun, one in which judges are given the authority to independently arrive at these conclusions. As a consequence of this modification, these agencies there might be an increase in the number of lawsuits that are filed when it comes to the businesses that they are responsible for. Supervising these agencies may also have a tough time navigating the ever-changing world of federal monitoring. This unpredictability has a negative impact on the environmental management and telecommunications businesses, both of which rely on regulatory advice to aid them in making decisions on their operations and strategies. As a result of the merger between AC and FATA, the latter has acknowledged that there are alternatives to manual conversion. The Supreme Court's decision has strengthened the legal actions that have been taken against Coinbase and Ripple. It is possible that this strategy will have an immediate impact on the cryptocurrency market, notably on companies such as Coinbase and Ripple. As an additional point of interest, the ruling is particularly relevant in light of the current legal problems that these companies are facing, for instance with the CC. The Securities and Exchange Commission's interpretations of the Securities Act have been a significant factor in the ongoing dispute between Ripple and the SEC about the question of whether or not its XRP patents are considered securities in accordance with the Chevron framework. In this particular instance, the courts have acknowledged the appropriateness of the article. In the ongoing legal battle between XRP and the SS, the courts will develop their own